welcome everyone to American University, Washington College of Law's Intellectual Property and Tech Law Supreme Court series. We are here to discuss the argument and the case of TikTok v. Garland that was heard this morning in 2.5 hours of oral argument. We have a terrific panel of lawyers who've all participated in the case, representing various friends of the court. We were unable to get either petitioners, counsels, teams to join us, but we have gotten gracious substitutes to help the audience understand briefly what the positions on the merits are. And then it was a 2.5-hour oral argument, so we've got plenty to talk about regarding that. I'm going to very briefly set up the facts, and then I will introduce our panelists, and then we'll be off to the races. Without going too deep, the U.S. government has been concerned about TikTok and its relationship with China for quite a long time. There was an executive order during the first Trump administration that never came to full fruition. There was extensive negotiations about a national security agreement regarding user data collected in the United States. Congress and members of the executive branch had many back and forths and looking for a way to divest the Chinese government's ability to control the company ByteDance, which is headquartered in the People's Republic of China, and which owns the U.S. subsidiary TikTok Inc., which is the petitioner. So it's a U.S. company owned by a Chinese company that has relationship with the Chinese Communist Party. So eventually Congress passed this law, and I'm going to show you elements of what the law provides based on the DC Circuit's nice summary of that. The thing that it regulates is a foreign adversary controlled application, and the prohibitions are essentially about data information portability. So users who are, if TikTok is shut down, individual TikTok users are required to be able to request and obtain their TikTok data to transport it to a different platform. And rather than prohibiting TikTok from doing anything directly, instead, it bars others in the United States from basically providing the support for an application, such as TikTok. So when this law is being described as a TikTok ban, it's a little bit less direct than that. It is about if there is not what the Act calls a qualified divestiture of ownership by ByteDance, or the foreign adversary that controls the application, then this prohibition on supporting that foreign adversary controlled application kicks in, which would have the effect then of making TikTok inoperable in the United States. So it's this is a First Amendment challenge and to an ownership structure regulation, but it's an ownership structure regulation about a social media platform. And so I'm not going to go too much deeper into that. If others during the discussion want to raise other specific elements of the statute, we can go there. But that's in essence what the law does. And the divestiture date is January 19th, the day before the new administration takes office. And if that divestiture has not taken place, or the Supreme Court does not issue an administrative stay or a preliminary injunction, then the prohibitions on supporting TikTok in the U.S. would go into effect, which we are told would cause TikTok users to lose access to the platform. Okay, so we have a fantastic panel. In the order of appearance, I'm going to introduce, I want to thank Ari Cohn, who is at the Foundation for Individual Rights in Expression, FIRE, and they filed a brief for FIRE itself and a National Coalition Against Censorship, the Institute for Justice and Reason Foundation in support of the applicant. He's a nationally recognized expert in First Amendment law, defamation, and Section 230, and serves as lead counsel for tech policy at FIRE. He is going to help us understand TikTok and TikTok users' positions in this case. We're also going to hear from Kufair Lang at White and Case, who filed an amicus brief on behalf of national security professors who are supporting petitioners. So you had former national security officials supporting the government. Here are national security professors supporting TikTok and the TikTok users. And then we'll hear from Jonathan Patchen at Wilkie Farr, who filed an amicus brief on behalf of internet law professors in support of petitioner. And I'm sorry, Kufair's a longtime appellate litigator, as well as working in trial courts and state courts across the country. And his litigation subject areas include copyright, patent, antitrust, administrative law, and other questions of statutory and constitutional interpretation. Jonathan's practice is in the litigation department, and he is a co-chair of the Media and First Amendment practice at Wilkie, and has an extensive experience in complex technology and other sort of complex civil litigation. And then supporting the government, we have two amicus. Peter Koharis is at his own law firm, Koharis Law, and they filed a amicus brief on behalf of the Foundation for Defense of Democracies in support of the respondent. Peter is also has agreed to help us understand the government's position, since the government has a standing policy not to participate in these discussions. He is the founder of his own law firm and is a recognized expert on international law and foreign affairs, and has nearly 30 years of experience appearing in trial and appellate courts throughout the U.S. And his litigation practice it covers commercial disputes, administrative proceedings, as well as challenges to U.S. government. And he has international experience with disputes in Asia and other parts of the world. And he was an adjunct, has been an adjunct member of our faculty. So thank you, Peter, for that. And then we have another Peter, Pete Torstensen, excuse me for that, who is the Deputy Solicitor General for the state of Montana, which filed a brief on behalf of 20 other, Montana, Virginia, and 20 other states supporting the U.S. government. He's the Deputy Solicitor General with the Montana Department of Justice and represents the states in all forms of appellate litigation, and has led multi-state amicus coalitions on a number of these cases. In fact, he has participated in one of our earlier discussions, and we were joking before we started that we didn't think he probably thought he would become a social media regulation expert when he took on the general practice of representing the state. Okay, with that introduction, I want to ask Ari to kick us off and just tell us very briefly sort of what the arguments were before the court when they came to the bench today, and then we can take it from there.
Thanks so much for having me. Yeah, I'm going to give you a 30,000-foot bullet point overlook, so please forgive any oversimplification. And if my book report is terrible, I hope somebody will mention whatever I missed. So on the TikTok side of things, their argument basically can be distilled to four major overarching points. First, that speech is definitely implicated here. The choice to use the algorithm provided by ByteDance is an editorial decision that is protected by the First Amendment, particularly in light of the court's decision in Moody recently. Which means, according to TikTok, that even if China could pressure TikTok into manipulating the algorithm, TikTok USA's choice to continue using it is still protected by the First Amendment. And forcing divestiture would fundamentally alter the expression of TikTok USA by cutting US users off from the rest of the world on the app, and in changing how it expresses and it curates and modifies content. The second point it makes is that the ban is clearly content and speaker-based, triggering strict scrutiny. They point to the law itself, which says that China may covertly manipulate the application's recommendation algorithm to shape the content that the application delivers to American audiences, to show that the law directly targets content. It also points to the law's exclusion of certain speakers. It only applies to services that host user-generated content, And it also excludes services and websites that are focused on product reviews, business reviews, or travel information, thus speaker discrimination. TikTok argues that it's not a law of general applicability that just so happens to have an impact on an expressive enterprise. It is in fact explicitly targeted at the expression itself, and therefore cannot be analyzed under laws of general applicability. It also argues that Congress can't just declare, under the speaker discrimination claim, one speaker different just on Congress's say-so, and thus avoid scrutiny because it treated that speaker differently. The third major point, I suppose actually, the third major point kind of coalesces with that, and it talks about media ownership rules. Obviously, there's rules about foreign ownership of TV stations and radio stations, and TikTok points out that these rules are different. They are predicated on the scarcity of spectrum, which allows the government a little more power and leeway in terms of determining who can have access to that limited resource. And then the brief goes on to argue that the law doesn't survive strict scrutiny. So the brief points out the government has not identified an actual concrete problem in need of solving because it admits that it has no evidence that the harms that it fears have ever occurred in the US or are demonstrably likely to occur. Instead, it rests its fears on what might happen in the future based on speculation of what China might be up to in the future. Second, it argues the government doesn't have a compelling interest in altering the landscape of expression to fit its liking. The government can't ban foreign propaganda, even when the foreign power completely controls the content, such as the author of a book or a propaganda movie created by a foreign power. Third, TikTok argues that the focus on covert manipulation doesn't fix this fundamental problem. And in fact, the government didn't even consider less restrictive means like disclosure. And there's no evidence that covertness was really Congress's concern. This is more of a post hoc rationalization that the court shouldn't really be crediting. Fourth, the brief says that the data protection interest similarly fails, both because the real gist of this was aimed at the content manipulation claim and data protection won't survive independently. So it's just a fig leaf. And in any event, the data protection rationale renders the law under-inclusive through its exclusions and through its specific inclusion of only services that host user-generated content, creating a serious doubt that the government's actually pursuing the goals that it says that it's pursuing. Finally, the brief argues that the law isn't narrowly tailored. Again, the government didn't consider any less restrictive means like disclosure. It also ignores the national security agreement that TikTok was negotiating and didn't just apply the data protection provisions that are applicable to, say, data brokers to TikTok and try to fix the problem that way. So that's a high level of TikTok's brief. On the creator side, and I'm going to ignore everything that's duplicative of this because there is some overlap. The creators argue, again, the ban clearly implicates First Amendment rights, but in a different way. So the ban infringes on the rights of Americans to speak to each other in their chosen medium, which is not interchangeable with other platforms. TikTok is a unique type of communication, just like Twitter is different from Instagram. The creators also argue that the ban infringes on the rights of Americans to work with the editors and publishers of their choosing and associate for the purpose of speaking. And they argue just like the government couldn't ban you from publishing or working with the BBC or Al Jazeera, so too it can't ban creators from working with the platform of their choice on social media. And third, the creators argue that the ban infringes on users' right to receive information, even if it's information that the government fears furthers a foreign country's interests. So the second high-level point of the creators' brief is, again, the ban is content and viewpoint-based. The creators argue that the law is clearly targeted at speakers with viewpoints allegedly antagonistic to U.S. interests. And they argue that the D.C. Circuit's attempt at distinguishing the targeting of curation that serves Chinese interests versus Chinese views is a distinction without a difference, because the former is always accomplished by the latter. Third, the creators argue that framing the ban as a divestiture requirement doesn't help evade strict scrutiny. Requiring divestiture and forbidding any cooperation or operational relationship with ByteDance necessarily entails a different publishing and editorial policies, which in turn modifies the creator's expression. And it also, the divestiture would limit the reach of the audience, cutting them off from the rest of the world and creating a content island in the US. Fourth, like TikTok, the creators argue that the ban fails strict scrutiny because the government cannot suppress ideas just because they are too persuasive and may benefit a foreign power. And this is so even when these ideas are coming directly from a foreign adversary. The rights of Americans to receive even foreign propaganda intended to influence American politics is enshrined in the history of our nation. And they point to a number of examples, one of which being the government didn't ban Pravda during the Cold War, despite the fact that it was entirely controlled by hostile foreign interests. And the ban is just that, an outright ban. It doesn't take the approach of FARA and require disclosure. It just cuts off speech wholesale on speculative concerns. And the government can't just ban an entire speech platform to curtail certain portions of what might occur on that platform that the government would like to prevent Americans from seeing. So compounding First Amendment violation on First Amendment violation there. And the brief also argues that the government could easily counter foreign influence attempts with its own speech, counter speech being the quintessential less restrictive means in these cases. And that is my, I don't know, couple-minute explanation of the petitioner briefs.
Well, no, it's great. And you see, I think the audience can see the layers of argument that have been put forward. Now, Kufir, let me ask you, I would think the national security community would be behind the government because there is a lot of suspicion about the Chinese government's motivations, and there is a lot of valuable user data that could be used in a variety of ways. And yet your clients think this is a problematic law. Can you explain why?
Yes, thanks for the question. That's a great question. So the issue that our clients, and we represented professors who are national security experts, and what they did is our focus in our brief is the national security agreement that ultimately the government refused to agree to. So it's a bit funny to call it an agreement. It was a proposal. It was negotiations, and ultimately it was 103 pages that were drafted. But the key point about the national security, I'm going to continue to call it an agreement. Proposed agreement perhaps is more accurate, but the key point is that it accounted for the government's asserted national security concerns, particularly of data collection and content manipulation. And what it also did was it gave the United States government unprecedented insight into TikTok's internal operations. And one of the kind of key points that trigger or that show the strength of the national security agreement, in addition to the ways that there were, an agreement with, TikTok US creating a new entity, working with Oracle and supervision over the source code and the algorithm. But ultimately, the key linchpin here is that in the event that the government determined that TikTok was not complying with the agreement, then TikTok would have to shut, or we call it a kill switch. It would no longer be able to operate in the United States. So what you see is the end game that is the statute accomplishes would also happen if the national security agreement was breached. And the reason why we take issue with just simply saying, well, we're just going to kill TikTok rather than implement a national security agreement is because our position is, yes, this is direct regulation of speech, and therefore it triggers strict scrutiny. And if it triggers strict scrutiny, then the government has to be able to justify its compelling interests and also say, well, we consider at least restrictive alternatives, and we've identified this less restrictive alternative. The problem that we also identify then is what happened at the DC Circuit. And prior to coming to White and Case, I clerked at the DC Circuit. And so the DC Circuit is a court that gets a ton of government cases where the government consistently says that it has national security interests. And as a general matter, the DC Circuit and courts generally say, well, we're going to defer to the government's professed national security interests. But the question in strict scrutiny is, okay, fine. No one challenges that the government can articulate a national security interest. The better question is, well, what does deference mean in this category? It can't just simply mean, well, the moment the government says two magic words, national security, that ends the judicial role of saying, well, we have to, apply strict scrutiny consistent with the First Amendment. And again, the government's point is, well, ultimately, we walked away from the national security agreement, the negotiations, simply because we just couldn't trust TikTok to comply, or we didn't trust that the PRC wouldn't exert influence over TikTok. And the reason why we think that justification is insufficient is because the agreement accounts for that specific concern. And so there's a second step that has to come into effect, in our opinion, which is assuming that you don't trust the PRC. In fact, that's kind of what's motivated this entire thing. Look at the agreement. Look at how the agreement addresses those things. Now, why is the agreement insufficient? The DC Circuit didn't do that. The DC Circuit simply said, well, ultimately, we find at certain points it said the agreement has broad contours. We don't actually doubt that it will be effective. The government even concedes that it has benefits, but the government simply just doesn't trust it to work. And because the government doesn't trust it to work, that's enough for us. And our position was, well, no, that can't be enough because the First Amendment demands more.
Great. Got it. And then, Jonathan, you're representing a different group of academics who have teach about tech in the First Amendment. And why are they concerned? What's their interest in this case?
Well, so yeah, and thanks, Michael. It's thanks for the opportunity to speak here. We represented a group of 35 internet law and First Amendment professors sort of across the spectrum that all had the same view that what the government is doing here is sort of classically problematic under the First Amendment, putting to one side your concerns about politics or a broader context. Traditional principles of First Amendment law, just when applied in this context, seem to point to one conclusion. And the concern that was motivating a number of our clients was that, is there a change, or is somehow speech protections going to be varied or different in an internet context, right? That's the same motivation that was concerned a number of the same groups of our clients in the Gonzalez case, in the Section 230, in the Moody decision from last term, and the same here. And a couple other points just to emphasize what we had in our brief was the government, obviously, and we'll hear about this more, wants to take the position that this doesn't regulate speech at all, that this has nothing to do with the First Amendment. And a couple of points beyond what has already been articulated, what we had in our brief, the first of which is the law targets a speaker based on what that speaker is allegedly doing. And it's amazing how one-sided the record was as the act was being passed, about how much there was an objection about the speech and the speech mix that was on the platform. Senators, representatives, all complaining or articulating the basis for their vote on that. And it's, sometimes legislative history and what individual legislators say is not terribly persuasive. This time it feels like it's a little bit different. And there's pretty good authority, Turner and other cases, that indicate that when a specific speaker is targeted, that is almost quintessential viewpoint discrimination. There is a viewpoint, it's being targeted, and this is a pretty unique law in terms of how draconian a viewpoint discrimination or targeted this was. The second point, and one that I didn't hear much in the oral argument, but it'd be interesting to see how this plays out, is how much power is given to the government to choose who the next editor is of TikTok. The president gets to personally decide whether or not the acquisition, the divestiture, and whoever is going to buy TikTok is going to be approved. And that has real clear implications. There's not some standard that says if it's met and they have these adequate data protection measures and it won't be sent to a foreign adversary, anybody can buy. this is a clear indication, at least from our client's perspective, that that is a change in what the viewpoint of what the editorial control is over TikTok, which is fundamentally what implicates speech considerations. And so for us, without repeating everything that Ari and Kafir have said, our concern is that if you apply the law as it exists, or at least exists prior to today, faithfully, that should get you to strict scrutiny. And strict scrutiny, even when you have a national security concern, and that's articulated by the government, doesn't mean no scrutiny. It doesn't mean rolling over. It means that the government actually has to come up with real concrete justifications. And as the DC Circuit didn't look at the sealed evidentiary record, and so just based on the public record, found that it was sufficient. And our clients were uniformly of the view that speculation of what might happen in the future is not enough to meet the standard for strict scrutiny, especially when there are, as Kafir was saying, other alternatives that are much more narrowly tailored.
Great. And that is one of the complications in this case, is that part of the record is classified, and what the court will do with that, especially when the Solicitor General pointed them to specific parts of the classified record to support the national security concerns. So speaking of which, Peter Koharis, tell us a little bit more about the government's, what we've just heard is this is clearly targeting speech, and it's all speculative. You don't have evidence the Chinese government has done any of the things that you're saying justify the law, but you nonetheless filed a brief in support of the government's position. And why? What is it about the government's position that you and your clients also agree with?
Well, one of the challenges, I think, for the court, and I think for us, quite frankly, this evening is, in many ways, we're speaking past each other. In many ways, and we're going to be doing it this evening, I'm convinced, because in many ways, in hearing some of my co-panelists, for whom I have tremendous respect, and not only for the positions they're taking, but also for the sincerity of their views and their clients' views, we're not inhabiting the same world. We are simply not confronting the same reality. And I've noticed some of what the petitioners, amici, and the petitioners themselves have described are quite contrary to what the government describes, and frankly, what we describe. And so let me just take two glaring big examples, which sort of encapsulate what the government believes or has argued. One, the government says, this isn't a free speech case at all. It is about control. Not a single speaker is targeted for content, not one. And I think the government is correct. Obviously, Jonathan, all of you don't believe that's the case, but I do, and I think the government is quite correct on that. And so, because I remember before I even got into this case and started researching the realities of TikTok and ByteDance, I remember thinking, what's the content at issue here? It's a divestment statute. What content is being targeted, specific content, or what specific speaker? And to my mind, the answer is none. And the government, I think, argues that. It's interesting, the DC Circuit, I don't think, bought that argument completely and said there are First Amendment concerns here. I think the court certainly thinks that there are at least some First Amendment concerns here. They certainly explored, for most of the case, the First Amendment concerns. And that gets us to the second issue, which is data collection. And the government says, wholly separate and apart from the control issue, the data collection issue is severable under the express terms of the statute, and that constitutes a national security interest that would justify the act, irrespective of whatever First Amendment issues may or may not be present. And then there was a colloquy both with during the oral argument with both sides about whether that was in fact severable, or whether the data collection was an afterthought and was a post facto rationale, or whether in fact it was intrinsically necessary. So those are, I think, the two big issues that the government is pushing. The last thing I would observe is I think the petitioners got themselves in trouble a few times because they took some very bright line positions in their briefing, in their oral argument. Maybe they thought they had to. I don't want to be critical of them because I've always thought this was a very tough case for TikTok and their co-petitioners. But they said, there's no evidence of ByteDance manipulating information or contents. And even in the petitioner's application for preliminary injunction, they quoted very, very shortly, or in short form, Mark Warner's reference to a Rutgers University study where it was all about content manipulation. And they used TikTok's very own methodology to demonstrate that when it came to issues like Taylor Swift or some other relatively content neutral subject, the difference between hits on Instagram and on TikTok were negligible. The Uyghurs, Tibet, Taiwan, Hong Kong, and other issues, including even Hamas, the war in Ukraine, issues where the Chinese government clearly had a strong national security interest, ratios of 40-1, 30-1 that could only be explained by content manipulation. And we hit that very hard in our brief. Secondly, the idea that I just want to correct one thing. It was not accurate that the government only could rely upon classified information. I thought the Solicitor General did a very good job, and not once but twice, pointing out to the government that even after ByteDance had agreed, and this gets to Kafir's point about agreement, ByteDance during the negotiating process had agreed to stop tracking journalists. They broke that agreement and tracked journalists to try to figure out who was leaking to journalists about TikTok and ByteDance. During the negotiations, she said it not once, but twice. And that wasn't in the classified part, that was in TikTok's own part of the brief that they, not the government, classified, but that TikTok sealed. So there's a lot of misinformation here about certain fundamental realities. And I suspect, I don't want to get bogged down into the facts, but my fear is, and that's why I'm raising it at the beginning here, my reality in all candor is quite different from some of what I've heard both on this panel and what I read in the petitioner's briefs. And we're responding to the reality which I'm aware of, which is also, and this gets to the NSA point, and we go into great detail in our brief about this. There are not one, there are not two, but there are 5 different national security laws issued by the Chinese government. You can go into our brief and explore them. They don't give the option, they require every Chinese company, including ByteDance, to comply with those laws. And those laws require an enormous amount of information be applicable to the PRC. I do not understand, Kafir, and I've not read the NSA anywhere near as completely as you have. I've just read accounts of it, in fact, to be completely candid. But I do not understand how, if it was as sweeping as you've described and as the petitioners have described, how it would comply with the demands of the Chinese government. To the contrary. And the reason why the government dropped that approach, as it indicated in its opening brief, is because it did not trust ByteDance and TikTok, and it had no way of independently verifying. So an agreement that can't be independently verified is, from the government's perspective, and I'm not a national security expert, I'm not a member of the intelligence community, but I think it's reasonable for a court to say, well, if the government is telling us that there was no reasonable way of verifying the national security components here and compliance, this is not an agreement, and it will never be a meaningful agreement. And I think, let me just stop with that.
Okay, great. And then thank you for that. And then Pete, what do the individual states have to add for the court's consideration?
Yeah, so, well, first of all, Michael, just thank you for having me. I think I'll just, highlight, so Montana part of our interest in this case, kind of stems from the fact that our state legislature passed a very similar ban on Montana, or on TikTok's operation in the state of Montana. That was predicated on a data privacy sort of rationale. Obviously, as a state, we don't have the same kind of authority or ability to pursue, national security interests kind of more specifically. But so our brief here kind of stemmed from, or kind of followed a lot of the arguments we raised in our own appeal, and that was primarily that the act here is, as Peter kind of highlighted, our initial position is that the act is not really targeted at speech at all. It's targeted at the operation within our kind of territorial jurisdiction of a social media company that actually is controlled by a hostile foreign power. And that hostile foreign power has access to reams of personal data of Montanans specifically, or that was at least the position in our litigation, that they would be able to use to sort of harm Montanans' interests. And so similarly, the act here seeks to divest, or to require ByteDance to divest from TikTok in order to kind of safeguard Americans' national security interests and things like that. And so I think our primary argument is that is not a regulation that's really targeted at speech at all. We made the argument that the Arcara case really should control, and that was primarily based on the idea that, like, because the act was targeted at conduct, and the act did not have the effect of singling out a speaker for expressive activity, that the First Amendment was not implicated at all. Now, the DC Circuit, the majority was not very persuaded by that at all, and they dismissed that quite succinctly. Chief Judge Srinivasan appeared to be more receptive to that argument, and so was interested to see if the court today was going to be a little bit more willing to potentially engage with that argument, but it did not seem like it really controlled or guided anybody's thoughts on the matter. But I think I guess the next point that we sort of moved to was that, like, this should either be kind of analyzed under O'Brien, or which essentially says that the court can, if an act regulates non-speech conduct that has an expressive element, then you would sort of evaluate it under an intermediate scrutiny sort of standard. And then I guess kind of moving on from there, you could sort of liken it to a more time, place, or manner restriction. So that was essentially the top line view of our brief, and rather than kind of, I guess, lingering too long, it might be good to get into some of the discussions about the actual First Amendment analysis.
Absolutely, yeah, thank you. So I guess, there was a lot of discussion about this sort of covert data manipulation, and Justice Gorsuch near the end really asked, how much work is the covert doing? And General Preliger tried to clarify that it was a disclosure requirement that simply said, hey, TikTok users, the Chinese government might be manipulating what you're looking at. Proceed at your own risk, would be insufficient, because you would not have the notice of when and how they were using the recommendation algorithm in a way that was sort of designed to produce results like the ones that Peter mentioned. So there's that covert data manipulation, and then there's the data security. The data currently lives on servers in Virginia operated by Oracle, but in the operation of the TikTok algorithm, every time you're using TikTok, some of that data is being fed back to ByteDance, and then if the Chinese government can order ByteDance to turn it over, that's the sort of pathway that is the source of concern. So, let me hear from you. Sotomayor, Alito, Gorsuch, there was it was a hot bench, and I'd be curious to know, like, of the maybe greatest hits, of the moments in the argument, what would you say were the places where maybe the justices either scored the point they were trying to or got the information they were trying to help them figure out where they're going to land on this?
Well, one area I think it will cover, Peter, you mentioned the fact issue, and you just Michael, you just mentioned Justice Gorsuch. I think Justice Gorsuch, stood out, I think, most out of all of the questioners because he had a viewpoint that was pretty unique. He didn't seem to have much of a coalition going. But one of the key points that Justice Gorsuch pointed out was he felt that there were disputes of fact. And I think he made that point in a number of places. And at one point, I think, Michael, you referenced this earlier, where the Chief Justice asked the Solicitor General, after she referenced the sealed appendix, like, well, did TikTok have ability to see that? And that doesn't sound fair. And so one of the points that I think were made, and this is just to be fair about what the DC Circuit did or didn't do, is that the DC Circuit is not a fact-finding court, and ever. And the way the act was enacted, the case starts at the DC Circuit, and the DC Circuit's opinion says, well, we find points of disagreement, but we don't find disputes of material fact. And part of the two sides are talking past each other is, I think, partially to blame because the DC Circuit did not really, roll up its sleeves to say, okay, are there factual disputes or are there perspective disputes on how these facts are operating? So I think to the degree that points were scored, and one area that makes this case tough for the justices is that there are some disputes, and the DC Circuit said, well, we're going to, kind of do this in a quasi-summary judgment way and say, well, they're not factual disputes because there's no dispute. You two are just, talking past each other, and the essential, like, no one disagrees, for example, on the terms of the NSA. So there's no factual dispute. And Justice Gorsuch doesn't really buy that. And then there's the issue of the sealed appendix. So I think, just to kind of wrap it up, one of the more difficult parts of how will the court dispose of the case, especially on an expedited timeline, is, well, what is it going to make of the facts? What facts is it going to say, well, these aren't in dispute, these aren't operative facts? And what of these facts can we say the government, attaches to the government's security interests, and therefore we're confident deferring to what the government said? Which of these facts are we uncomfortable with and think, hey, actually this weighs in TikTok's favor? And we couldn't get a clear read on that, but what I found was there was a clear read on there are facts that are in the air, and that the court is going to have to figure out what to do with.
I think that's why they might have shied away from talking about whether the government had satisfied its burden of proving the problem. I think, that's a harder question. If they can kind of rule from 60,000 feet, they're going to try to do that as much as possible, just because of, exactly what you just said. And I think that colored where the arguments went today.
Yeah.
Yeah, and I think, Kufir, one thing that was interesting on the fact question specifically is, obviously, one of the things going into the argument that I was curious, like how the justices were going to navigate, was the ownership structure and how that sort of impacted the First Amendment analysis. And obviously, Justice Gorsuch, like, some of his factual concerns were like, what happens if ByteDance demands, or if the PRC demands this sort of information? Is it like undisputed that, they're going to have to turn this over and things like that? And so, like, questions like that obviously impact kind of the First Amendment analysis, and not having clear findings on that obviously will, I think, complicate the court's analysis.
Yeah. One other, I think that's right. And the court sort of understands how there was a lot of talk about the source code and an algorithm, and they sort of get it. Although at one point, Justice Kagan was just saying, well, it's just a search engine. And it's like, well, not quite.
Well-
But
Well, one
just,
thing,
yeah, go ahead.
yeah, just to add to that, there are two dimensions, and I hope we get to talk about it because I think they are interesting. They're not IP issues, but I think they're very fascinating issues. One of the things that we tried to do in our brief, and maybe this isn't the right forum, but I hope we all can get together later on in the semester for a follow-up, is this isn't your grandfather's propaganda. This isn't receiving, Pravda, getting a subscription to Pravda, and it's not getting, pamphlets in the mail that maybe you have to sign up and agree to receive from the post office before they'll deliver them to you. This is a type of, it's not even speech, and it's not even content in the traditional sense. What we're learning, and our brief tries to go into this, is, and there's a professor at UPenn Law School, Mike, and we quote her in our brief, is, cognitive warfare, and some people call it psychological warfare, but it operates on a level that, and the justices didn't get into this at all, which I can understand why they didn't, why a FARA-like disclaimer wouldn't work. Now, I did think the Solicitor General did a good idea, had a good response saying, look, having a general disclaimer saying 1 of a million products in our store may cause cancer, good luck trying to figure out which one that is. I think that was a clever and smart response. I thought it was effective. But the other challenge is, this isn't really just speech that can be combated with more speech, Ari. This operates on a level that is, I don't want to use the word subliminal, but in a way that, influences behavior, influences, it operates in a way that it's much more about marketing. And, advertisers, as we've found out since the early days of television, don't make arguments about why soap A is better than soap B. Some of them do, and they have tests and stuff, and maybe they'll say 4 to 5 dentists or something like that. But many times they don't operate on a rational basis at all. It's not speech, it's not content. It's a type of sort of feeling or manipulation or appealing to one's sense of fill in the blank. That's how this operates, and I think that's the covert part that the government was trying to get at in passing the statute. And I don't think that came out in the argument very well.
I had to push back on that because, what is speech? What is persuasion? How do you differentiate speech and persuasion that appeals to creates a feeling? All speech, all persuasion does that. You could count any speech as cognitive warfare. You can, count it as misdirection.
Wait, sorry, but we want to focus on the argument at the moment. Now you're just having your own argument, but I mean,
well,
I think
Peter, you and I'll have our own events.
But I think
We'll grab coffee, Ari.
The court has said these recommendation algorithms are equivalent to editorial decision making. So I think we're already in that world. But Peter Koharis, I hear loud and clear what you're talking about in terms of the power of the For You algorithm and the ways in which early TikTok users were saying, I think TikTok knows me better than I know myself. I didn't know I was gay, because of the power of the recommendations to target the interests so precisely I would agree, unprecedented. But let me ask another question. Justice Barrett was also
Michael, on that.
Yeah.
I did think that there felt like there was a real subtext of the Moody discussion and decision from last year about algorithms and really whether it was speech. And to me, it wasn't direct in any of the particular questions, except for perhaps through some of what Justice Barrett was asking about. But it does feel like there is that real disagreement, pretty sharp disagreement, as to whether or not those algorithms and which algorithms are speech, which ones reflect editorial discretion. And it was interesting, some of the panelists who were in the majority in Moody, Justice Kagan, sort of suggested that all of those algorithms were, and some were not. And I wonder, the most interesting question for me, I don't think that there's a lot of dispute or disagreement from the panelists as to how this case is going to come out at the end of the day. Now, I think if you took a poll, you're going to get, most of us are going to say the act is going to be affirmed. Like the DC Circuit's going to be affirmed. I don't know if anybody disagrees with me on that. The really interesting question for me is, on what grounds, and what's that split going to look like? I expect Justice Gorsuch to dissent, but who else and how are they going to split? Where? Is it speech? Is it a Justice Jackson that strict scrutiny really is not fatal in fact anymore, but is much easier to satisfy? Those are the, I don't know how that comes out, but there seemed to be no clear consensus or majority as to what the reason was or what is going to be.
So I agree with that, and I wanted to maybe Justice Barrett, she was really looking for the way through on this and really wanted more clarity about what speech am I supposed to be looking at and what level of scrutiny. And she seemed pretty clearly signaling that intermediate would be, she would be willing to recognize a speech interest, but apply intermediate scrutiny, which is not fatal. But I wonder if you all agree with that we would, I mean, on that question of, I agree with you about the ultimate outcome, but do you think they will sidestep the First Amendment altogether, or will they find their way through with some intermediate scrutiny-based rationale?
My best guess is that we're not going to have a majority.
Yeah, that's exactly what I was going to say. But I think you're absolutely right about what Justice Barrett was doing. And I think you kind of actually saw that when she started talking about Lamont and talking about how that restriction worked directly on Americans. You could see her trying to move off a little bit. It's yeah, I also think it's very possible you don't see a majority on the rationale.
I imagine I guess I do think that there will probably be a majority, but my sense is that the court might take a very sort of narrow tactic. I mean, it did seem like lingering in the background, the data collection interest did not seem to like engender as much controversy as I thought it could. And so like, I could easily see the court, if it's willing to sort of disentangle the covert content manipulation from the data collection interest, just leaning on that one interest. That being said, it's not clear to me that they had agreement that you could just entirely disentangle those two interests. So if they feel like they can't, then obviously I do agree with Ari that we're probably not going to we're not going to have a very like a solid majority. Maybe it's some plurality in which you're counting votes. But if they do think they can disentangle the interest, I would not be surprised for them to lean, I guess, more specifically on the data collection interest.
On the upside, if you don't have, if you have a plurality and not a majority, you're maybe not creating the awful long-standing precedent that creates the problem in the future is maybe one strategic thing they might be thinking.
There's timing thing too.
No,
right?
go ahead. Yeah, the timing.
It's 9 days, right? The 19th. I can't recall the last time that I've seen the Supreme Court sort of like, here's the decision, bottom line, opinions to come. Like I would be really interested to see if that's the outcome that's going to happen here.
District courts do it all the time. So
yeah, of course. Yeah, totally. Some courts don't ever offer a rationale, but I could see that. And that would be an interesting, because they may want to have some time to think this one through. And I don't see how you pull together anything that doesn't have real risk of real damage, apart from a sort of a sui generis situation here, right? Like if you really undercut what it means to have strict scrutiny, that has big implications beyond this case. If you are really tightening and saying this isn't speech at all, then you've got a lot of domestic social media companies that are going to be screaming about what they thought they had just gotten in Moody, right? So there's a lot of things to thread, and 9 days to do it is another scary thing.
Well, I thought you were going to say that as opposed to domestic media companies, I thought it was, I think, the Creators Council, when he threw Temu under the bus. I remember thinking after that description, that's next up for Congress. When he described all of the data collection there, I thought,
yeah, an entire public policy department hit their head against it.
Oh my gosh! I thought if the House Judiciary Committee, I think we know what we're working on next, gentlemen. If we want a bipartisan, start the year off on a bipartisan foot, I think, that is, I think that's the big question, Peter, Jonathan, and Ari, all of us have raised is, could this be something really narrow and a per curiam just to get this off the plate because it's 9 days? And then they sort of deal with this, hopefully with a little bit more time and maybe a little bit more of a factual record next time? Or would it be a plurality decision and everyone just sort of throws their spaghetti against the wall and you add up, okay, does this thing survive or not? I don't know the answer to that, but this is clearly not going away. Congress, I think, this is the start, unless this act is thrown out. And even then, I'm not sure this is going away, even with President Trump, or President-elect Trump taking office. I'm not sure that these kinds of issues are going away anytime soon.
We're overlooking one key benefit to the 9-day thing, though, is there's no opportunity to do Justice X joins into A through B and 4, 6, 7, 8.
Well, my own instinct to just join the panel for just a minute is I think the chief is going to work really hard to get a majority. He seems to have a real concern and interest about the developing law that applies to social media. And I'm thinking now to the Fourth Amendment context, and really recognizes how important and unprecedented this is and wants this court to actually speak with one voice. And it's tough because these are cats that are hard to wrangle. And Kufir, I see you've got one response to that. Let me throw one last other question. Mr. Francisco kept offering, all you have to do is ban us from sharing our data with anyone. And the Sorrell case says, wait a minute, you can't do that, right? Like, the Sorrell case was the one that struck down the state law that prohibited the sharing of prescription practices by doctors with the pharmaceutical companies. And the data sharing was treated as a speech act that was subject to strict scrutiny and was struck down. So I was curious for Mr. Francisco to think it would be constitutional for the court, for the Congress to tell TikTok it can't share any of its data, because isn't that regulating speech based on content?
Short answer, in my view, is yes, but any port in the storm. Survive divestiture or ban, and then figure out how you deal with what you just did to Sorrell.
Yeah. Kufir, you were going to weigh in on something else.
Yeah, so I think a couple of things about, what do coalitions look like in this short time span, and the Chief Justice's role in particular. So I'll kind of work backwards. One thing, I agree that I think the Chief Justice is, he controls the pen, he has a lot of weight in these circumstances. But at argument, it sounded like he was kind of staking out one of the more aggressive positions. And he, in general, he's harder, all the justices are hard to read at argument, and a lot can happen when behind the scenes. But I think that kind of weighs against, I don't know how persuasive or what type of coalition he can build, when it sounded like he was on the kind of a very, I'm not very much interested in strict scrutiny at all. The other thing I would say is particularly about the algorithm and the speech and the next steps here. We're going on, I guess, like year 3 or 4 of the court really struggling with the algorithm issue. And, it first jumped up, and we've mentioned the Twitter and case from, I guess at this point, it's 3 terms ago, where they just ultimately, the Section 230 case, where the court just said, you know what, we're just going to effectively dig it, even though it wasn't a dig, but it was a dig. And what I'll say is there, because I worked on an amicus brief for Microsoft in that case, where at that point, the court, it was clear, had no idea what an algorithm was. And there was a lot of emphasis on how do amici and how do the parties just explain technology. And I remember at that argument, Justice Barrett, and this happened again, and Moody got a lot of credit because she knew what Etsy was, right? Then last term, we get Moody and we see Justice Barrett's concurrence, and she issue spots. She pretty much just says, hey, here's the case that's happening. And that solo concurrence carried a lot of weight at the DC Circuit, and I think it drove Chief Judge Srinivasan's solo writing there. And so I think one of the things that kind of makes where the court is now different is that at this point, I think the justices are starting to kind of wrap their minds around how these, platforms operate. I think they've clearly started to embrace the analogy between the algorithm, the platform, and, for example, the Washington Post. And that's one of the things that Noel Francisco kind of leaned on is, well, what about the Washington Post and then and Bezos, and how social media platforms or internet platforms are effectively making recommendations, and that's not different than, that's a form of speech. And the court kind of seems to understand that parallel. I think, again, though, where the next step comes is, and this is where the next steps are dangerous, and the spinoff effects is, right now there's a lot of Section 2, there's a lot of products liability and a lot of other cases that are directly going at algorithms. And there's this attempt, and this is kind of one of the background issues here, is how do you, or to what degree can you separate the algorithm from the platform, and can the algorithm be analyzed as an entity in itself? And this case is the worst possible opportunity to do that, just in my opinion. And I think Justice Kagan, early in the argument, it sounded like, she was going to be kind of very aggressive, and she asked tough questions to the petitioners about that. But I remember the back and forth she had with the Solicitor General about, well, what does it mean to be covert? And then she says, well, what about the Communist Party and this, that, the third? And so at that point, again, it was very hard to read her. And I think just to kind of, it's not helpful to say, yeah, this thing is muddled, because I think everyone agrees on that. But what I did want to say is, I just think the court is going to be as narrow as possible, not only because time demands it, but I think in cases where there is a widespread agreement on disposition, that is where you are most likely to see the extremes kind of cancel each other out. And in this case, if we go on argument, Justice Gorsuch and Justice Roberts, I think, are going to sit this one out. And everyone in between, potentially Justice Barrett, because she's been issue spotting, because she's kind of been able to wrap her mind around this publicly, I think she has a lot of sway and a lot of trust.
To follow up on that, I agree with that. And I think two of the easier ways, the obvious ways that they could go in a narrow direction, and maybe I'm naive in thinking perhaps per curiam, maybe not, I don't know, is, control, the issue of control. If they buy, and I do, the government's depiction of ByteDance as controlling TikTok, controlling the algorithm, and that ByteDance, the influence of the CPP, the Chinese Communist Party, or PRC writ large on ByteDance, I don't think is harder by any means. I think it's pretty clear. That's one way. The other is, a foreign adversary designation or a foreign adversary ownership. And that gets you even away from the, Germany owning Politico, or, Jeff Bezos and the Washington Post. It's the foreign adversary component of ownership / control that I think could, alleviate a lot of uncertainty for at least US social media companies, and leave that for another day.
So we're a little over time. I want to, but I'm going to ask one substantive question that is sort of cross-cutting to what we've been talking about, and then ask you to tell me if you're willing to take a chance on what you think the final lineup will be. But so I'm now speaking as a professor who's been teaching internet law since 2001, and sort of watching the network itself develop, and then the law around the network develop. And you know, you have to take a systems approach to understanding the internet and its interactions with society. And what I find frustrating, and you're all litigators, is that in the litigation context, the court is only being presented a small piece of the elephant, just a small little slice of what's happening inside across the network, and doesn't see the kind of, this is a different use of the word intersectionality, but within the technet, that doesn't see the intersection of, for instance, the markets for user data and the advertising business model that relies on that user data as being what powers the modern internet. And so for me, one reaction was, well, wait a minute, the US government is suddenly treating all of this user data as a national security asset, which it would be. You know, at one point in the past, you would have spent a lot of money gathering this kind of information if you were engaged in espionage. But now we're all publishing it. It's all there for the taking. And so if we're really worried about the national security implications of user data flowing to foreign governments, it's easy. You can buy a lot of this. You can't buy all of it. And it's true that, you know, being inside and watching all the uses that you can monitor if you're in ByteDance headquarters is different from what the data brokers can sell you. But as to Justice Kavanaugh's concern about recruiting spies in the future, you know, the people's susceptibility to being recruited, I think that data is easily bought and sold in the modern era. So even as the justices start to learn a little bit more about how a platform works, how algorithms work, I don't see them understanding the larger sort of context in which data flows happen, in which we lack any privacy regulation of any real means. And so in the absence of that, how are they supposed to think about these platforms and the user data that are necessary to their economic functioning when we get the government sort of selectively coming in and declaring a national security interest in one piece of the pie without sort of engaging in the broader regulatory possibilities and the regulatory gaps? So that's a big question, but you've all been, you know, following these cases, and I'm really curious from the litigator's perspective, how do we help educate the court to think more systemically about these cases so that they're more aware of what the downstream effects might be if they're careless in their language?
The problem of Article 3, right? Case and controversy. That is sort of the fundamental problem of sometimes these big decisions being made that have a lot of that cross-cutting impact by this court, right, or by a court, and that I'm not sure there's a good answer to that, right? Are there 9 super legislators? That's I mean, that's what the legislature is supposed to be, right? That's what Congress is supposed to be, is understanding all of those. That said, and to the extent that this, you know, this is my own, I'm not speaking on behalf of any clients or otherwise, I do think that if there's a place where the court's going to come out, really it's this data protection that Peter was talking about. And I do think that the court is likely more aware than was shown maybe in the briefs or what was in the argument about the different data protection regimes, right? I wouldn't be surprised if most of the justices were aware of sort of what Europe is doing with respect to data protection, some of the stuff that the FTC is doing with respect to data protection. And maybe there's fair debates about whether it's too much, too little, whether Europe is going too far or too little. But if there is a place, and this is sort of, I could see like a Justice Jackson, Justice Thomas, the Chief Justice, lining up in an area where, as Peter was saying, is data collection, and this is a foreign adversary with that data collection that is not subject to or in ways that we particularly trust with allies. That becomes a national security interest. That may be where it comes out, and it's narrow. But I don't know how you educate them about all of those things,
right,
in Article 3 setting.
Yeah, I think one thing that sort of seems a little bit interesting, the court kind of expressed obviously these concerns with the net choice cases in terms of like litigating these things as like facial challenges. I mean, I know here part of that like arises just given the kind of the fact that it starts off in the DC circuit, and so there's obviously less opportunity for kind of the ordinary course of factual development. But I mean, there is like obviously a great danger of like opining on these sorts of laws when you're dealing with like out really a very kind of comprehensive factual record and how these laws kind of interact with other laws. And so like reaching these kind of big First Amendment conclusions, or doctrinal conclusions on things without really having tested, the facts and stuff, like does, I guess, leave us a little bit out over our skis, I think. And so in some regards, like there is the manner in which these cases are often litigated, especially lately. I know we see this a lot in some of the cases we've been litigating in Montana, like that there's I guess a very clear preference to pursue facial challenges given the ease of like dealing with, just kind of legal arguments. But then I think when you do that without kind of like just developing records in ways, like you do run the risk of these like, doctrinal points being decided without, the factual record necessary to kind of sustain them.
To kind of piggyback off of both Jonathan and Peter, like, and I apologize for being a little chippy here, but one thing we could do is Congress could go back to actually having hearings with experts, developing legislative records and history instead of these dog and pony show markups or quote unquote hearings where all they want to do is yell for the cameras and get these, TV sound bites. We could actually engage in in-depth policy making and legislating and actually do the work. That would go a long way. But nobody wants to work anymore, right?
So Jonathan, I appreciate you sort of starting the lineup conversation. Let's close with that. Anyone else want to predict, Peter?
Oh, I just wanted to say I was going to not push back, but take off my litigator hat and put on my national security hat and say that, an even bigger systemic or interstitial, whatever the phrase you used, issue for me is that, the courts are a lousy way to deal with what I believe are national security concerns, right? We one of the reasons why this act took place was not simply about TikTok. It's about, China's approach towards the South China Sea, towards Taiwan, towards the Uyghurs, towards Hong Kong and the democracy movement, China's industrial spying, use of spy balloons, China's hacking of US government websites, of US credit card companies. I mean, this is part of a larger national security effort, and we go into this in our brief. And so to sort of like take these each as sort of like a litigational issue and sort of separated from the larger issue, I think is really deceptive. That said, I am very sympathetic as somebody who does a lot of human rights work to Kafir's observation at the very beginning, which is, even strict scrutiny doesn't mean no scrutiny. And if we're just going to defer all the time to the government because there are national security interests at stake, and we don't have any kind of, to piggyback off of what Ari just said and others, and Peter said about, facts and fact findings, then that can be scary as well in terms of our larger national security, in terms of the freedoms that we enjoy as Americans. And that's really the challenge that, as litigators, this is just a crummy way to go about dealing with these larger systemic issues that we've talked about here today.
Fair enough. So any other guesses as to who writes and what
I hope I'm wrong.
What kind of lineup?
But I'm going to go 6-3 against TikTok. The dissenters are Kagan, Gorsuch, and Sotomayor, and there's a plurality with Barrett, Jackson, Kavanaugh, and Roberts. I don't know who writes. And then Thomas and Alito off doing their thing.
I mean, I think I got the feeling sort of 8-1 if it's very narrow. If they like reach more broadly, then I think we could start getting into much more fractured opinions. I wouldn't be surprised to see just either a plurality or 5-judge decision with 3 or 4 separate, concurrences, or concurrences in the judgment, but dissenting on certain rationales. But yeah, I guess my top line guess is maybe either 8-1, 9-0 with Gorsuch writing separately. I don't know who's the majority pen.
Anyone else?
My favorite, one of my favorite quotes from T.S. Eliot is, the only form of humility is, the only form of wisdom is humility, and humility is endless. I am still eating humble pie after the presidential immunity case and the fact that the court even took it, let alone what they decided. I am out of the prediction business entirely.
Fair enough.
Predict
All
then,
right.
Peter, that you'll be closest to what the outcome is.
Yeah. All right. Well, with that, I want to thank all of you for your time and your thoughts. And we will, we've got 9 days, or unless we see a stay or something like that. So we'll know sooner than we normally do what today has wrought. But we appreciate you all spending your time with us. Same goes to you in the audience. And until the court takes another one of the cases of interest to us, we'll sign off and see you next time. Thanks, everyone.